Welcome back to This Week in Immigration, our conversation on the stories that matter right now in immigration policy. I'm Jordan Lapierre. This week on the program, the latest on the DACA drama in the House, whether schools can contact immigration authorities over undocumented students, and changes to the rules around student visas. But before we start, remember, you can subscribe to this podcast and all of BPC's podcasts on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, you can find more information about all the topics we discuss here on the show. Just go to bipartisanpolicy.org/immigration. So joining me today on the program are the usual suspects. Theresa Cardinal-Brown, she's Director of Immigration and Cross-Border Policy. Hi, Theresa.
Hi, Jordan.
And Cris Ramon, he's a policy analyst. Hi, Cris.
Doing well. How are you?
Good. Let's start with what we've done a lot lately. As the Congress turns, the ongoing drama over DACA and whether the discharge petition attempt will succeed. We talked about that in the last episode. But the latest wrinkle, House Republicans meeting on June 7th at the request of leadership to discuss a DACA alternative. Now, I should say we're taping the show a day before that meeting, so we don't yet know what will come out of it. But Theresa, what does House leadership hope to get out of that meeting?
So, as we talked about last time, House leadership is not thrilled with this idea of a discharge petition, which takes the control of the House floor out of their hands and requires a floor vote on these 4 different immigration ideas. So they have been working behind the scenes to try to get moderate Republicans and conservative Republicans talking together to see if they can come up with an alternative piece of legislation that could be put on the floor and forestall this discharge petition. So Congressman Denham, a Republican from California, who's been the leader of the moderate coalition of Republicans working on this and who has spearheaded the signatories on this discharge petition, has been talking with Mark Meadows, who's with the Freedom Caucus, the very conservative members, Republican members of the House, to try to see if they can come to some sort of compromise agreement. If they are, or whatever they've come up with, will be discussed at this June 7th Republican-only meeting. And the House leader, Paul Ryan, is hoping that they can come to agreement that can get a majority or even 218 Republican-only votes to pass. That's his hope, but frankly, that's a long odds play, in part because there's so much, I think, that the parties, the conservatives and the moderates are debating over right now. One of the biggest sticklers is whether or not under this legislation, DACA recipients, dreamers, would actually get a pathway to citizenship. That's something that the more conservative members don't support, but the moderate members insist on. So that's one of the things. The other things are what else goes along with this package for the DACA and Dreamers. So we understand they're talking about border security measures, possibly including authorizing money for a border wall. They're talking about some of the other quote unquote pillars that President Trump had when the Senate was debating. So that includes changes to family-based immigration and the diversity visa lottery. So these other things in the mix could also impact whether or not, the 218 members of the Republican conference can sign on board. And we even talked about whether or not it would get any Democratic votes, right?
Right.
The leaders of the discharge petition, including Denham, have said if this process fails, if we don't get something we can support, we think we have the remaining 3 votes. There are only 3 signatures short on the discharge petition now. They think they have the remaining 3 signatures that would force this petition, and then we'd be in another ballgame.
So you've sort of laid out the 2 possible futures here. Either this meeting leads to an agreement, which probably staves off the discharge petition, at least for now, or it doesn't, which probably gives it a bit more momentum. I don't want to prognosticate what's more likely since this is going to air after it's happened. It's kind of pointless. But I do want to spend some time in each of those 2 possible futures. So let's say, to start, that the meeting produces an agreement on DACA or a process for working towards some sort of agreement. What would happen next?
So if the leadership and the Republican conference can agree on a piece of legislation or a framework for legislation that they would then put into place, and that's sufficient for the moderate Republicans to hold off on the discharge petition, the next thing would happen is probably they've agreed on some principles that would have to be put into legislative language, and then the leader would have to schedule a floor vote for that. Many of the moderates have demanded that floor vote try to occur before the end of summer, within the next month or so. So it would have to be pretty soon, I would think. And then we see whether or not that would gain a majority of votes on the floor of the House. Republicans have like a 25, 26 seat majority. They can afford to lose a few people and still get 218 if all of them are supportive. and they wouldn't need any Democratic votes. But chances are on immigration legislation, almost always, it's almost impossible to get anything passed without some votes from the other side of the aisle. And Democrats have been skeptical about this process. They're holding off a little bit to wait and see what comes out of it. But I would say that there are a lot of things being floated that they're raising their eyebrows out of. So my guess is that unless this bill that comes out of this process can get 218 Republican votes, the chances are it passes the floor of the House are low.
And if this meeting then doesn't produce a breakthrough, that probably gets the discharge petition over the hump, right? That's what its sponsors are saying.
Yes.
I think as of this moment, it's 3.
Yep, 3 signatures short, and the sponsors believe that they know who those 3 signatures are, and they're willing to sign on once they know that this leadership process has fallen. It would be 3 more Republican signatures, most likely, because all of the Democrats have now signed on. So what happens then? Yes, that means that by, I think, the earliest is June 25th, this rule that allows for a floor vote on 4 different immigration proposals must be allowed to be voted on the floor of the House. So there'd be a sequence of votes, first on the rule, then on the Goodlatte's immigration bill, which has been out and gone through committee for a while, but doesn't have a majority of votes to support it right now. A version of the DREAM Act, which would provide permanent path to citizenship for the Dreamers. Some version of a bill that had been introduced previously by Congressman Hurd and Congressman Aguilar that would be a DACA dream permanent status in exchange for some border measures, maybe not in technology, infrastructure, maybe not necessarily border wall, and something that the House majority, that the Speaker would introduce. That could be a version of what didn't make it through the full Republican conference. It could be something else we don't know. So the parameters of those 4 pieces of legislation are still up for debate because any of the sponsors can introduce substitutes. They could tweak what we know is in bills so far. So we don't quite know how that would play out right now.
So let's keep going with the hypothetical future, though. What happens if something does manage to pass the House through that process? Might the Senate actually take it up?
Well, Majority Leader McConnell has said, we already did our chance. We did this in February. Nothing passed. I have no desire to bring this up again, even if the House passes something, and we don't know whether the president will sign it anyway. So at least for now, he's saying hands off. That having been said, particularly I think if something passes the House with a lot of Republican votes, and say the president indicates, I could live with this, or there's something here, or I could work with it, that may change the dynamics. There may also be some members in the Senate who say, you know what, we actually believe it would be good for us if we try to have a vote on DACA. Mm-hmm. Certainly the Democrats will be pushing hard to try to have a vote in the Senate on some form of legislation. Now, whether it would be the same that passed the House or something else, that's another question. We hear that some of the people who were working on bipartisan bills back in February are again talking, sort of contingency planning in case something comes out of the House and they start working on it again. We don't know where they're at. So I'd say it's a iffy chance right now. Things may get tighter the closer we get to, say, the end of the fiscal year when the Senate has to pass appropriations legislation. The president's going to insist on money for his border wall. That may be another opportunity when this comes up again, and then you may see some trying to make deal making then.
That's a wrinkle that we should get into in a future episode. I think this isn't the last we're going to hear about funding for.
This is the ongoing soap opera of DACA and as Congress turns. So there's never an end to what we talk about.
All right. Thanks, Theresa.
Sure.
Let's turn now to recent comments by Education Secretary Betsy DeVos. Last month, in testimony before a House committee, DeVos answered a question from a Democratic congressman who recited incidents in which some undocumented parents were arrested near schools after dropping off their children. She was asked whether she felt that principals or teachers who find out a student is unauthorized should call immigration authorities, and she responded that it was a school or community decision whether that should happen. This caused a lot of response from schools, immigration activists, and others. Theresa, I think it's helpful to start with a review of what exactly are the rules about schools and undocumented immigrants, and why was this response so controversial?
Sure. So we'll go back to a Supreme Court decision from 1981 called Plyler v. Doe. And in that case, the Tyler Independent School District in Tyler, Texas, was trying to say that the state did not have to fund the education of children of undocumented immigrants or undocumented children. In a 5-4 decision, the Supreme Court said, actually, all children in the United States have the right, a constitutional right to an education in our K through 12 system. And they have equal protection under the 14th Amendment. So it's a constitutional right. and that is regardless of their immigration status. And so schools can't deter or prevent students from registering or attending classes based on their immigration status. And it seemed that the secretary was aware of this because right before that answer she gave that you quoted, she actually mentioned, there's a Supreme Court saying all kids have the right to education. So she knows about this. So later, let's talk now about California and Prop 187. So Proposition 187 was a ballot proposition passed in California in 1994 that, among a lot of other things, would have required schools to kick out undocumented students and report undocumented students they found to immigration authorities. There was a lot of litigation over this, and that part of that proposition was struck down by a federal court in California. It was appealed to Ninth Circuit. Eventually, there was a change in governance in California, and so they settled that case. But the outcome of that case is a pretty strong legal case that no, schools can't report the unauthorized immigrants. So the legal authorities are pretty settled here. Schools can't do anything to deter undocumented students, and they can't bar students based on their immigration status. Theoretically, I guess schools might be able to call, but they'd be sued immediately. And I think a lot of courts would say that if teachers are calling ICE on students, that's a deterrent to students getting their education. So that's why this was such a big deal. The fact that the Secretary of Education kind of indicated that schools can or should be a place where enforcement happens. And later, I should note that she did put out a statement trying to clarify her remarks where she said schools should not be enforcement zones. And then in questioning in a Senate hearing, she said, actually, no, she did not think that immigration or that school officials could call ICE. So she backwalked it. But it's out there now, and it caused a lot of controversy over the last week.
Well, I think you're heading in this direction. There's a second half to this question, right? So if schools can't deny education to students based on their immigration status, where does that leave ICE with respect to their activity in your schools? Aren't they deemed to be sensitive locations?
They are, and I think that's where this originally came from. So ICE has a policy, we've talked about it here before, called Sensitive Locations Policy. And these policies say that in places that ICE deems sensitive locations, generally, immigration enforcement activity should not occur at those locations. Schools are included in that in part because of all this legal history that says kids have the right to get their schooling. But what has happened recently is that ICE has started conducting operations around the schools. So parents who have dropped off their children at the schools may be arrested by ICE after they've done that away from the school. That sort of, I think, caused a lot of controversy. People are saying, well, if the school itself is a protected area and you can't do enforcement, but you're enforcing around the school, how does that jive? Mm-hmm. The upshot of all of this is that the increasing way in which ICE is conducting its enforcement operations is affecting immigrant children and immigrant families in ways that people are starting to question, and that's where this is coming from.
Okay. Thanks, Theresa. Finally, today, Citizenship and Immigration Services has announced changes to its policy for cases where students on certain kinds of visas are found unlawfully present in the United States. Cris, can you walk me through the new policy?
Yeah, so at the beginning of May, USCIS issued a new memo that's essentially impacts when students and visa holders who have an F student visa, a J1 exchange visa, or an M vocational student visa fall into unlawful status. Now, the question is, what is unlawful status? And generally, unlawful status or unlawful presence is when an individual really isn't authorized by the U.S. government to stay in the United States or to be in the United States. So one of the examples is you enter the country illegally. That's one example. Another example is that your visa expires. That's another example. And finally, you do something on a non-immigrant visa that violates the term of the visas, and then you're in unlawful presence. And this is important because the length of unlawful presence has implications for when you can return to the United States or whether you can seek other immigration benefits. The new policy that comes into effect on August 9th basically impacts when students fall into unlawful presence status. And specifically, the most important part of this new change is specifically the day after they're no longer pursuing a course of study or authorized activity, or they're engaging in an unauthorized activity. This is the one that I think is getting the most traction or the most attention from advocates, because we're talking about, suppose that they drop a class.
Yeah.
And the moment they drop that class and their course load changes, or they do something like, say, for instance, they're not authorized to work in the United States, but say a student on an F1 visa who's at Kansas State has a side gig. the moment that happens, they start falling into unlawful status and begin accruing it. So that's the key thing. But like I said, the new policy is explicitly saying also the day after these other conditions as well, that the moment that those things happen, the day after that, they fall into unlawful status, start accruing unlawful presence.
I see. So what does this change then from past policies? How's this different?
This is where you start really noticing how this new policy is a pretty radical shift in the treatment of these individuals. The prior policy was basically this. If a USCIS officer is reviewing an application from somebody who had an F1, a J1 or M1 visa, suppose you're an F1 student, you want to get an H1B high-skilled visa, you want to stay in the United States and work. If USCIS detected anything that this individual did that would have violated the terms of their visa, on that day, they would essentially start accruing unlawful status. They would fall into unlawful presence and start accruing unlawful status. Basically, the time would start kicking up from there. An immigration judge, suppose an individual who's on an F1 is put in deportation proceedings, an individual's put in front of them, and basically the judge says, well, they determined they violated the terms of their status. That's another instance. And in the expiration of the status, if they had what's called a date certain, that means an end date for their visa, that's another instance. But basically, this new policy completely introduces a whole set of conditions that basically make it easier for USCIS to basically state, you know what, it's not the date that we detected this, it's the date when you did something wrong. That's the big shift. It's not, hey, we noticed this, or an immigration judge noticed this. It's, oh, you did something wrong 6 months ago or a year ago. That's the big shift. That's why it's really important that it's no longer that authorities detected, it's when you did it.
So why will this policy change matter for both international students and for colleges and universities, higher education institutions?
So it's important because, at the beginning of the segment, I talked about the implications of accruing unlawful presence. Well, the thing is that there are things, in immigration law called the 3 and the 10-year bars that basically state that the longer you stay in the United States, you may be banned from entering the United States after 3 years for a period of time, generally from 180 days to less than a year. Or if you stay over 1 year, you could be banned potentially for re-entering the United States for 10 years. That would definitely impact students who they didn't even know that they had actually fallen into unlawful presence status and then so start accruing this time. And for universities, it puts them in a bind because basically with these visas, they're responsible for overseeing these students and for gathering the data about basically the activities that they're engaging in through a system that's called SEVIS, which is the Student Exchange Visitor Information System. So universities and sponsoring organizations have to maintain all these records and these details. And so what happens is with the new policy, it could be the case that these organizations don't have the up-to-date information, may have actually put in information that could potentially put the student put them at risk of falling into unlawful presence status, and then kick off this accruing more unlawful presence that could lead to the bar. So basically, universities are in a bind to ensure that they're staying up to date with the information and they have to be accurate. But for the students, and this is really the most important one, it could be the case that they didn't even realize they violated the terms of their visas, and all of a sudden they're caught in this bind where they're subject to these bars.
Okay, thanks, Cris. That's our show for this week. Thanks for listening, and a special thanks as always to our producer, Emily Schroeder. Please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And don't forget to subscribe to this podcast as well as all of our podcasts on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time.